Looks like the parties are ready. It's my understanding Mr. Russell will argue for appellants and Mr. O'Brien for appellee. Is that correct? Okay, Mr. Russell, you may begin.
Thank you. May it please the court, counsel. Along with me is Jenny Juring, my co-counsel from Lane and Waterman, and Joe Pollack is in the gallery. We are here on behalf of Scott County and Deputy Hill asking for what we've always asked for. Reversal of the district court on the plaintiff's one remaining claim. And that one remaining claim is a constitutional tort. And this court in Burnett, the Court of Appeals in its previous holdings in Christensen and Dishman have, and along with the legislature, have all said that those claims don't go forward. So what we're asking for is that this court to apply its previous holdings. Plaintiff filed their claims with 8 separate counts. Those were strategic decisions. Litigants make them all the time. We appealed based on 2 separate grounds. 1, statutory right to appeal, and 2, an interlocutory appeal. Those were strategic decisions to apply under both of those rationales. And this court made a decision on which one to accept, but it was a strategic decision. Just
Clarify, so we did not accept your interlock, right? So you're only here on the qualified immunity.
Your Honor. And so when the court issued its ruling, it said that the appeal was granted under 670.4A, and the interlocutory appeal was denied as moot. Now, this court has since said that 670.4A doesn't apply retrospectively, right? But we're here, and the court, when it addressed the retroactive concerns of 670.4A, it was in the context of subparagraph 1, the immunity provision, and whether it should apply retrospectively. No court, this court or the Court of Appeals, haven't looked at whether subsections 4 and 5, which give the right to immediate appeal, should be applied retrospectively. So that's an open question, but the concerns with retroactive application of an immediate right to appeal are very, very different than applying immunity retroactively. Candidly, do I wish that the immunity had applied retroactively? Yes, but I'm not going to argue for cases to be overturned at this point. But the right to immediate appeal doesn't have that same concern of taking away a right. In fact, immediate appeal in a case like this is fairly common. Under federal law, which often tracks state law in these type of cases, there's an immediate right to appeal on these cases. And so whether this court had accepted it under the statutory immediate right to appeal or interlocutorily, we would be in the same place.
I tend to agree with you. You know, the case is in front of us, and now we need to apply the law. But, you know, the somewhat elaborate discussion that you just gave us, you know, wouldn't that suggest that what we should do is just indicate that the constitutional claim doesn't go forward, but then send the case back, and you can argue in the district court whether it's too late to amend or, you know, do anything else at that point in time. I mean, it would appear, just watching the video, that there's potentially a valid claim under 42 U.S.C. 1983, or at least, you know, one that would be able to go forward, right?
One, I don't necessarily, I don't like to be elaborate, so I apologize. I'm a pretty simple guy. But
criticism, I just think it's procedurally the case is more complicated than the typical case.
I agree with that, Your Honor. And I think that timing of this case is the only thing that has us here in front of this court on this floor rather than downstairs in front of a 3-judge panel, right? If this case had been filed today, all the law would be settled and we wouldn't be here. But instead, we've got this much more elaborate, to use your word, situation. So yes, I agree that it would be reasonable to say that the constitutional claims are dismissed based on previous precedent and the cases that have been applied, and remand this to the district court. But
A little bit there on, I think I might disagree a little bit with Justice Mansfield about what actually is before us. We granted interlock, you had a right to appeal the decision denying qualified immunity. That's what's immediately appealable. You described it as similar to federal cases. And my understanding of federal cases, which very rarely grant interlock but do make an exception for qualified immunity, are still very narrowly tied to the qualified immunity issue. And so in my view, I think it really is just a qualified immunity issue that's before us. And if that, and that's why it's here in the middle of the case. So if that's the case, why shouldn't we just address qualified immunity and send it back and let the district court address the rest of it?
Because litigants deserve predictability and certainty and decisions.
Okay, fair, but so do the plaintiffs. And when Burnett was changed, kind of the landscape in the middle of their case, which is still going on, but you happen to have filed an appeal, which you were allowed to as of right, that kind of stopped things. And so aren't they entitled to the same fairness to kind of determine then, now that things have changed, what's going to happen within this case that's still going on?
Your Honor, I think I understand your question, and the response to that is that the plaintiffs have, Ms. Thorington, have talked about the concurrent jurisdiction. This is in their supplemental briefing at 1, or not at 1, at page 11. They talk about the trial court below having concurrent jurisdiction of the matters below. And so the issue with that is that the summary judgment was granted in favor of the defendants on all but these constitutional torts, including the wrongful death claim, which is not affected by the Burnett decision, right? That's a common law claim. The district court below, which plaintiff argues has concurrent jurisdiction, has not been asked to revisit that decision. The plaintiff argues that the district court has concurrent jurisdiction. They have not asked to amend their petition below yet. And so if you take the plaintiffs at their word and say, yes, the district court has concurrent jurisdiction, they haven't taken any actions to address those concerns.
Just a practical question. I mean, we're pretty far into the argument. What is it that you want us to do? Okay? At the end of the order, there's going to be an instruction about this case. Do you want us to dismiss the appeal? Do you want us to remand it and dismiss the district court action? What is the specific instruction that you're seeking from this court?
We ask this court to remand the case with instructions to dismiss the lawsuit.
On that point, this is an interlock, or it's an appeal on the qualified immunity issue. Plaintiff had no obligation to file a cross appeal on the qualified immunity question. So you have, on the wrongful death claim, it was summary judgment on the emergency response immunity, correct? So even if the constitutional claims were dismissed, the plaintiff would still have an appeal as a matter of right post-remand on that question, correct?
If that was what this court chose to do, I think the court has some inherent power to to resolve cases. But
the summary judgment ruling is always an interlocutory ruling. he or the plaintiff had no obligation to appeal from that interlocutory ruling until all the claims are disposed of, and you have a final order disposing of all claims. So if that's true, and there's still a potentially live claim that'll come back on appeal, why wouldn't we just remand this to the district court and say, apply the law as it currently exists? The district court knows about Burnett. They can engage in motion practice. You can argue about futility of amendments, whether it's fair to apply it retroactively, and then we get a final judgment, including the wrongful death claim. Like, I'm just struggling to understand, as you're arguing, what it is you want us to do and why.
Your Honor, we would ask that you remand the case with instructions to dismiss the claim, and I understand your concerns, but the
problem. I may disagree a little, there may be different viewpoints of, what's, I think we've granted the appeal on the qualified immunity issue. So once qualified immunity is in front of us, even whether the qualified immunity statute is retroactive or not, if you don't have a claim, then that in effect, that's qualified immunity. So whether, we agree on this court that we should reach the merits of the constitutional claim or not, it does seem that you're maybe overreaching by asking us to tell the district court to just get rid of the whole case. I mean, that wasn't what the only thing that is before us is that one claim, this one claim, right?
that's consistent with the briefing. I recognize that we have asked, when I asked for a full dismissal of the claim, that's based on a judicial efficiency public policy matter. This case is, this incident happened in 2018. This case has been pending in front of the district court and now this court for quite some time. And the issues are well known by the litigants. The issues are well known by this court and the district court. And in the interest of judicial efficiency, I think that the dismissal of the suit, instructions to remand with dismissal is fair. If I recognize that nobody has had the right to appeal the decision on the wrongful death claim. That goes back to my argument that, Ms. Thorington claims there's concurrent jurisdiction at the district court, and they've done nothing to pursue that. And so it's a question of waiver and fairness. If
Do that, I don't understand.
the district court to reconsider their decision on the wrongful death claim, they haven't asked the district court to amend their petition.
Rules, they have no obligation to do anything until there's an entry of a final judgment disposing of all the claims in the case. And at that point, they have an appeal as a matter of right. So are you saying if you don't file a motion to reconsider on a summary judgment that you waive the claim?
This is a unique set of circumstances, Your Honor, that this case has been pending long enough. The law changed in the middle. Everybody knew that this was going to be the issue when we got here today. What do we do with this? But they haven't done. If they had filed a motion to reconsider the motion for summary judgment, then we could have dealt with that concurrently, as they say the district court has.
Distinction between the appeal being moot and the case being moot. So you sought a statutory appeal as a matter of right on a qualified immunity question. Under Burnett, there is no claim anymore. So the qualified immunity issue on appeal is moot. And if that's right, then why wouldn't we just dismiss the appeal and whatever happens in the district court happens, right? And then the parties are free to litigate it, they're free to have motion practice, and that would be consistent with our case law. The appeal is moot, it's a jurisdictional question, we dismiss it, and the parties are free to do what they want. Why isn't that an outcome dictated by our case law?
Dictated by the case law because of the court's inherent authority to hear disputes that are in front of it. if this case is going to be remanded, and the court sees fit to say, okay, apply the law, which includes dismissal of the constitutional tort, but, then allow the plaintiff to address the wrongful death claim. But I would ask that this court instruct that there be no allowance to amend to apply federal claims, because then we're starting over 5 years down the line. We're starting over with discovery, because federal claims are different than state claims. And I see I'm out of time. And the prejudice to my client of having to do that is great. And also there's a consideration of the possibility of different inconsistent outcomes.
Present to the district court judge. The statute only gives you a right of appeal on a qualified immunity question. And you're making arguments about amendments and pleadings and prejudice and bias, none of which has anything to do with the immunity question that's before us, correct?
It has nothing to do with it. But, Your Honor, in our briefs, we asked that the case be, that the claims that were addressed by Burnett be dismissed. That's what we asked. And that's what we're still asking this court to address that. Thank you.
Mr. O'Brien?
Good morning, Counsel. I'm a little hesitant to get up here and say much, because I'm not sure if the posture of the case really allows me to get into much of the underlying legal issues that were briefed, and particularly giving the questions that you all had for my distinguished defense counsel here. I do think that ultimately the appropriate thing to do is to dismiss the appeal and send it back to the district court.
I don't think that's quite correct, and here's why. It's not moot. Moot means no matter what we do would not make a difference in the case. It doesn't mean controlled by other case law. So if there is a live controversy at this point, whether the constitutional claim goes forward or not, you've asserted it, it's there, and it's in front, and it is now in front of us. The issue of qualified immunity is an issue that would prevent the claim from going forward. Now that the appeal is in front of us, we can say that we could say the city is qualified, is not qualifiedly immune, is immune, period, for a reason that we've already held a year ago in the Burnett case. So it's not, whatever it is not moot. I don't think we can dismiss it. At least that's my opinion. The issue, but I do think there is an open issue whether, what you should be able to do on, if there's a remand or on remand. And I want to hear from you as to, what you would intend to do and why you think you should be able to do it.
Well, I think I should be allowed to generate any pleading that I can based on the facts of this case that's legitimate, because the law was changed in the middle of our litigation, and fundamental fairness, due process. I mean, it requires us an opportunity to try to rework the pleading in a way that does work. But I could tell you right now, if you go back and read my pleading in this case, I think it complies with Justice McDonald's requirements for a common law claim that was recognized at the time of the adoption of the Iowa Constitution in 1857. I mean, you repeatedly said in Lynette, in the your concurring opinion in Lynette, which I think really helps explain the majority opinion in Burnett, that these were our founding fathers in Iowa in 1857 would have recognized these common law claims, and they put this constitutional provision in, Article 1, Section 8, that protected unreasonable search and seizures. They put it in there to protect those rights and to literally write them in stone in the Constitution. And qualified immunity, what qualified immunity? There was no qualified immunity in 1857. Qualified immunity didn't come around until the Harlow decision in the 1970s. So I'm not really sure. I think we go back to what you said in White, which was, look, the assault claim goes forward because that was recognized back at the time the Iowa Constitution was adopted. And then the defendants came in and said, well, wait a minute, what about all our claims regarding qualified immunity and these other issues? And you said, well, those are affirmative defenses, justification, go back and plead and prove them, and we'll see you later. Now, that was on a motion to dismiss, but I'm not really sure what qualified immunity issues are left.
I think that the district court read, I think, all of your counts except for the common law wrongful death count and the loss of consortium count as being a constitutional tort claim. Is that fair?
I believe that's fair, yes.
If we were to view those in the same way that the district court treated them, do you agree that they would all fall off under Burnett and White and our other cases from last term?
I don't think the common law death claim would fall off under Burnett and White, but I do think the other ones would, the due process, the other claims. Loss of consortium is I just do it that way. I probably shouldn't. It's not really a separate count. It's a damage issue.
So I'm clear. The common law wrongful death claim, the district court granted summary judgment on against you. The constitutional tort excessive force claim, which I think is the one that you're saying maybe continues on because it is a common law type claim that would have been around at the time of the founding. That issue would not be for us. Is that fair?
But it certainly might not be such a bad idea to give the court a little elaboration as you go back, but that may be, maybe you're issuing rulings that aren't.
1983 claim?
Your Honor, I guess it depends on what you do with this. I mean, in all my other cases, and, this has been kind of a mess for us. I understand. You guys, you reversed the decision because you thought it was wrong. I respect that. I'm trying to make it all work and figure it all out. I might want to make 1983. I have to talk to my client. She's sitting back here. I might want to do that. And I think I should have an opportunity to do that since the rules changed in the middle of the litigation. But it depends on what you say. I like the court we're in. I like the district court. I like you guys. I'm happy to be here. Yeah, it may be a while since you've been up in front of the 8th Circuit. It's sometimes not all that friendly. So, this might not be a bad place to be.
If you bring a 1983 claim, probably, yeah.
Russell talked about, well, then everything gets delayed, but that would be their choice. We could add the 1983 and then just stick with our same trial date. But I think I ought to be able to give the option to that. Isn't that the fundamental fairness that's allowed? I mean, we made strategic decisions based on the laws that existed, and that changed. And I'm not here whining about the fact that the law changed, but I guess I would be back whining if I wasn't allowed to take my case and try to make a lawsuit out of what is left after Burnett and White and the other decisions.
Clarified. I just want to run through the claims and the posture so I understand where we are. As of now, there is an excessive force claim under the Constitution where summary judgment was denied. So that's a live claim, so to speak. You have substantive due process and inalienable right claims that were dismissed, I think on the grounds that the Article 1, Section 8 kind of precluded the field. You have a wrongful death claim that was dismissed, but maybe you'd agree that you would have appeal as a matter of right from that dismissal once there's a final judgment on all the claims. Is that right?
Sudden emergency grounds and immunity, which, if I'm reading these cases correctly, the legislature can regulate these claims, but they can't abrogate them.
Is it your position then we should just remand the case for application of Burnett? We still have a live claim. I understand you don't want application of Burnett, but it is what it is. And then you can deal with any kind of motion practice that you want in terms of amendment in front of the district court judge.
I like Burnett a lot better than I like Justice Mansfield's dissent in Godfrey, because I think I still have some breathing room under Burnett. But yeah, I mean, if that's the outcome, that this case just gets remanded and we let the district court grapple with these issues, I mean, I can't complain about that. I think that's reasonable. It keeps you folks from being in a position where you're making some decisions that haven't been thoroughly reviewed at the district court level. I mean, Judge Lawson wrote a great decision. I'm always happy to get up and talk about defending a well reasoned district court decision, and I don't often get a chance to do that when I'm on appeal. It seems like I'm usually on the other side, and so today is a refreshing something new for me. But yeah, if that's the worst thing that happens today, I can live with that. Let Judge Lawson have another crack at it based on your new decisions, and let it fall out where it may. And ultimately, if either one of us aren't happy, we'll be back or in federal court. I don't really have, I mean, I was prepared to talk a lot about the facts and stuff. It doesn't seem like you're too interested in any of that. I really don't have anything else to add. I think that's kind of where we're at. You did what you felt you had to do with reversing Godfrey, and now we're trying to deal with that in the most efficient way possible. And I'm sure you'll all come up with a good answer and a good response for that. I just hope it leaves us with an option of making whatever claim we have left viable if we can. So thank you.
Russell.
Thank you. I have 2 points briefly that I want to address. One is the general rule against getting multiple bites at the apple, and 2, that nomenclature, what you call a claim, shouldn't dictate the outcome. The plaintiffs in Burnett, Carter, White, Venkis, Richardson, and then Dishman and Christensen below didn't get a second bite at the apple. But that's what Ms. Thorington is asking for. 2, in Ms. Thorington's supplemental brief around page 18, there's this theory that nomenclature and the words used to describe a claim shouldn't dictate the outcome. But that's exactly what's happening here, is that the argument by Ms. Thorington is that, hey, if I use different words, then my claim would survive. But that shouldn't be the way it works. You shouldn't be able to avoid this court's holdings and the law simply by using creative pleading. Because once you do that, then the law breaks down, and the predictability and the fairness to the litigants fades away. So with that, we'd ask that the case be remanded with instructions to dismiss the lawsuit. Thank you.
Versus Scott County is hereby submitted, and the court will recess for the morning.